Hello, everybody. Hi, Billy. Hi, Ava. Billy, I don't have any of your treats up here. I have to get them. They're in the kitchen. I missed you guys. I didn't do a whole lot of nothing. Actually, I did a whole lot of nothing. I was not feeling well. I spent a couple days in bed. You can't eat these. They're not for kitties. The best I can do is a licky treat, and I can't do that at this exact second. I can't even do the greetings until I give Ava this final treat, because if I set it down, Billy's going to get it. And I don't know if Billy can have everything that's in it. I know cats are naturally lactose intolerant, and this has yogurt in it, so I best wait. Don't be jealous. You just had licky treats, and I will give you more. He's been so cuddly. Like, even though I had my BiPAP on, he slept at my face. And cats don't like the forced air pushing on them. He didn't care. He stayed right by me the whole time. So did Earl. Now, I was very well comforted in my time of need. So, hi, Earl. Ava slept at my head. Earl slept right behind the back of my knees. Billy slept at my face. Tiny Kitten Esquire would have been there, but Billy and Tiny fight, and so Tiny avoids Billy. Otherwise, I'm sure they all would have been on the bed. All right, baby. You good? You good? Yes, you are. You're a good girl. Oh, thank you. I did buy, I bought the Temptations treats, but I forgot to grab them. How dare I? I know. Hello, Manuel. You are first, and I hope you get to feeling better. I'm sorry you're sick too. Hello, Nana Laura. I hope you have fun. Thank you for stopping in and saying hi. Hello, Auntie M, my love. Hello, Linda Applegate, sweet. Hello, Jerry Matthew Boyd. Have I told you lately how much I love my coffee pot? I do. I love it so much. And yes, I have taken medicine. No, I am not on drugs. I'm just going to get that out of the way right now. What are you doing? What are you doing? Messing with the curtain. That's what you're doing. Oh, she's judging, all right. Actually, Billy's judging tonight. Hello, floor lover. Good to see you. Hello, Spider-Man. Hello, C-Rex, my love. Oh, he's knocking the mouse right out of my hands. Thank God this one doesn't have an eject button. He would push it. He was the culprit back in those days. Hello, Buzzy Pug. Good to see you. Casey Battles, my love. I'm so happy you're here. Yeah, you remember the eject button. All of a sudden the stream would just go dark. And it was Billy's fault every time. It just like that. He just flopped down on the mouse. Hey, buddy. Buddy, you're not making this easy on me. Look at this big old boy. Look at this big old boy. 17 pounds of fluff and love right there. Yes, look at the face. There, you go. I put the padded blanket out specifically for you guys. Knocking my stuff all over. I don't have treats. I will get them, but I don't have them to give you right now. Ow! Jerk face. Hey, Billy. You stop it. You go get your aggression out somewhere else. So I'm not the one. And neither is Tiny Kitten. Don't you dare attack Tiny Kitten. I know. I know. Look at that tail go. Oh, he is in a mood. Earl, don't you scratch that. Oh, goodness, you guys. There's behind me is. Whoa. Sorry. Behind me is 1, 2, 3, 4 scratch pads. 4 different scratch pads. And you choose my desk. Sorry, Billy. Oh, man. Yeah. He got his tail in the way. And he stepped on the fan remote at the same time. There. Never a dull moment. Never a dull moment. Oh, I'm sorry. Well, maybe when you get it fixed, if you come up this way anyways, deer hunting or not, we'll get together for lunch. We'll figure it out. Otherwise, there's always next year. But I am sorry to hear about your truck. That sucks. But you can't really go deer hunting without a truck. It's kind of a necessity. Well, if you want to take the deer back home anyways. You could always just drop it off at my house. Or not, you know. So, we're gonna go to Connecticut first tonight, and it's a pro se dad, and he's fighting for his rights very well, actually. And then there's some meddling family involved, and you know that's always entertaining. But keep your eye on her name is Hepburn, I believe. She's in the middle. She's the aunt. Keep your eye on her theatrics. Yes, he will. But then he's got to get horses to pull him, or a couple of mules, you know. You can't just, drive a buggy. You could borrow Ava. We could hook a harness up to Ava and have her pull. We'll just go shoosh, and away she go. Maybe we'll get lucky and she'll fly like a reindeer. Oh, and there was Earl. I guess Billy and Earl are playing. I'm gonna have to keep an ear out for this one. All right. So let's head on over to Connecticut. And then after Connecticut, where do we go after Connecticut? I can't remember. I know we end in Michigan. I can't remember what the case is after Connecticut. Oh, Judge Brindell. I think he's Texas. So Connecticut, Texas, Michigan. That's where we're going tonight. Thank you guys so much. And thank you for your patience and all of your love and support while I wasn't feeling well. You guys are the best.
Good afternoon, Your Honor. We're now on the record.
All right, good afternoon, everyone. We are here on two related matters. The first is Chandler Brill versus Lori Hepburn, and that is DBD CV 255-022-339. My apologies, Mr. Brill. And then the second matter is Chandler Brill versus Tom Esposito and Clifford Garnett. And that is DBD CV 255-022-340. This is a combined hearing on both matters, but we'll hear them separately. If all counsel and Mr. Brill, if you could identify yourselves for the record.
Chandler Brill, pro se. Your Honor, can you hear me?
Yes, I can. Good afternoon.
How are you today? Hope you're well.
Yeah, thank you.
Just, if Your Honor, please, Ray Pluff representing Thomas Esposito and Clifford Garnett. I couldn't hear Mr. Brill. I don't know if his microphone needs to be turned up. But I would submit, Your Honor, I've spoken with Attorney Leventhal, and these motions are virtually identical, and I was planning to argue the motion, and then if Mike has something to add, I think he would do that. I don't know if Your Honor.
Let me just identify myself for the record.
Let's just first identify themselves for the record.
Michael Leventhal, I represent Lori Hepburn, and that is in the case Brill versus Hepburn, which ends in 339S. And to follow up on what Attorney Pluff said, yes, the motions are pretty much identical. The arguments are identical. So we're both going to be making the same argument. I have no problem if Mr. Plouffe goes first, I can follow up because they're identical arguments as to it being a strategic lawsuit against public participation, and the fact that our position is that both Mr. Esposito and Ms. Hepburn had probable cause to bring their claims. So if the court will allow it, I would allow Mr. Plouffe to make the argument.
All right.
Your Honor, may I interject?
Who's speaking?
Chandler Brill?
I'm sorry. So your screen froze. Yes, Mr. Brill, go ahead.
So the original case was filed by Lori Hepburn on November 17th, 2021. She released her counsel, known as Jill O'Connor, on approximately May 17th or 18th. The case had already been won, and when Tom Esposito and Clifford Garnett showed up, it was June 9th, and the judge had already issued a no contact order. There was no probable cause whatsoever on
Wait,
behalf
we're not doing, wait a minute, we're not, hold on, everyone. Let's reset, okay? So what we're here to do is first identify ourselves for the record, and I think everyone's done that. And I think that what we're going to do is first we're going to hear the motion to dismiss in the Brill versus Hepburn matter. I understand the overlap, but I want to give Mr. Brill the opportunity to respond as to each case, because each case is going to have a separate decision. Mr. Brill, how this works is the move-in, so it has nothing to do with the fact that it's an attorney, but the move-in goes first, and then the person who's opposing the motion responds. And so in the matter of Brill versus Hepburn, we're going to hear the special motion to dismiss at docket entry 103 and the memorandum in support at docket entry 104. And what I'll do is while the movant is the movant's attorney is addressing that, I'm going to ask everyone else to please silence your microphones, and then we'll hear from Mr. Brill in response.
Okay, thank you, Your Honor. Michael Leventhal then for Lori Hepburn on that matter. We have filed a special motion to dismiss pursuant to General Statutes 52-196A. Our position is that Mr. Brill's lawsuit against my client for vexatious and malicious prosecution is an attempt to prevent her from exercising her right as a third party to seek visitation of her niece pursuant to 46B-59. It's a strategic lawsuit against public participation. She has exercised her rights, which the statute 46B-59 was amended to allow someone in her position. She's the aunt of the minor child, and she had, for all intents and purposes, after her sister passed, she had acted as the mother of that child. She'd taken care of that child. Mr. Brill exercised his rights. He is the legal father of the child, and he exercised rights to have the child live with him. But she petitioned the probate court first, and then she petitioned the Superior Court for third-party visitation. Whatever happened in the probate court, I know Mr. Brill has made a big deal about, he says he won. Whether he won or not, and I don't think he did win, is not the issue. The issue is whether she had probable cause to bring those claims, and she did. Even the documents that Mr. Brill submits in support of his objection, which are documents from DCF, from social workers, they all have a similar pattern in which the social workers note that the minor child at times felt threatened by Mr. Brill, that the minor child wanted to be with her aunt. Ergo, she had probable cause to bring both claims. And then in the Superior Court claim, Mr. Brill did prevail, but the Supreme Court, in the decision at 348 Con 827, Hepburn v. Brill, remanded the case back to the Superior Court because they said she had a colorable claim. Ergo, she had probable cause, and that case is still pending. They have hearings scheduled in March of next year. So that case is not resolved in Mr. Brill's favor, which is a condition precedent to bringing a claim for vexatious litigation. And so it's our position that everything Mrs. Hepburn has done has been with probable cause. The underlying Superior Court action is still pending. He's attempting to thwart her attempts to exercise her rights as the aunt of this minor child for visitation. Whether she wins or loses isn't the issue. It's whether she had probable cause. And then the issue is whether he can prevail in this underlying lawsuit, which he can't because she had probable cause. And that is a complete defense to a malicious and vexatious lawsuit. Kazemi versus Allen, 214 Con App 86106 case that I actually tried. I represented the plaintiff in that case. Judge Crumage said that, and the appellate court sustained that case. So that's basically the sum and substance of my argument. I know Mr. Plouffe is going to probably have a lot more to add to that. Thank you.
All right. And so in connection with this particular matter, Mr. Plouffe, Attorney Plouffe does not have an appearance in that matter. So I'll wait to hear from, yep. No. I just want to, we have a self-represented individual. I want to make sure we proceed in a very particular fashion.
Understood.
All right?
Yes, Your Honor.
So, and although I may have, I want everyone to know, although I may have stumbled with Mr. Brill's name at the beginning, I want you to know that I've read everything that you've submitted. So I understand very well what happened at the probate court, what happened at the Superior Court. I understand the applicable statute. So thank you very much, Attorney Leventhal, for your argument. It supplements your briefing. I'll now hear from Mr. Brill.
Thank you.
And specifically on why the motion to dismiss should not be granted.
So the probate court 210700 had nothing to do with statute 46B59. It was a custody and guardianship claim that included visitation also, but it didn't have 46B59 whatsoever. It was a cloak and dagger, secret filing, ex parte. I didn't even know it was being filed. I didn't even have representation at the time, and I won without even being there on immediate custody. Immediate custody was immediately denied by Judge Maxim. Then, and just so you know, by the way, Your Honor, the opposing parties have accessed every possible court, including probate court, Superior Court, and the Supreme Court. There's absolutely no interference or obstruction whatsoever. Here, petitions filed in probate court, Superior Court, and the Supreme Court are assertions, not facts. And I just wanted to make that clear. For the only thing that's been fully adjudicated is what's occurred in probate court. It was a fully adjudicated case. It resolved completely and entirely in my favor. Immediate custody was denied. Temporary custody was withdrawn. The health and education custody withdrawn is part of the 46B59 case, but that's been withdrawn. So I do have probable cause per se. Removal of guardianship was withdrawn.
No, not per se, pro se. You're pro se litigant. No, okay. That was lame.
Appointment of guardianship was withdrawn. There was also two penalties: a no contact order and a psychological evaluation issued on the aunt. There was also another win too on a lack of subject matter jurisdiction, but that's related to the 46B59 case. The DCFS reports completely exonerate me. There was no abandonment, no abuse, no neglect whatsoever. It turns out Hallie, who I loved very much, Your Honor, was the primary caregiver, not Lori. And the fact that Lori claimed she was the primary caregiver is her self-report, and it has not been adjudicated. The best interest of the child is with her father. Today, the child is an honor roll student. She's 5'5", 110 pounds. She's starting forward on her JV soccer team. She has no weight issues. These are just ridiculous claims that the aunt has made. It just shows want of probable cause. The clearest indicator of the want of probable cause is the DCFS report, where within a week of the filing on December 2nd, they indicate that the aunt has made contradictory statements. The father
Excuse me, Mr. Bill. It really spent a considerable amount of time looking at the history of this matter, which is rather extensive. For this particular statute, though, it is significant that the case, it was remanded by the Supreme Court and that it is still pending. So, I'm not going to ever cut you off in terms of your argument, but I think given this particular case, that is something that you need to address, the fact that the case is actually still pending.
So when they approached the Supreme Court, they forgot to tell the Supreme Court that there's a no contact order, that on visitation there's a psych eval, immediate custody was denied, temporary custody was withdrawn, and removal of guardianship was withdrawn, and appointment of guardianship was withdrawn. And
She forgot to tell them that? Did you see her when he mentioned that they ordered a psych eval for her? Instantly, she covered her face. She's like, oh, I don't want them to know this either. Well, too bad. You shouldn't have misled the courts, because now he can use that against you.
never even had standing to sue for these things. It's inherently vexatious. But the probate case was won fully by me, and that's what this case is really about. Okay, the fact that they did an end around and seemed to have circumvented the no contact order in the psych eval, that's a separate matter. It's a separate case. This is regarding 210700 that occurred in probate court district 4 in Northern Fairfield probate court. And the day before they withdrew that matter on July 19th, they filed for third-party visitation in Bridgeport Superior Court. So there's two separate cases.
I understand that, yes. And I'm asking you to address the fact that the Superior Court case is still pending.
The Superior Court case is still pending, and I filed a motion to dismiss. It's getting argued on Friday on a prior pending action. So they've tried to link these two cases together, but they're separate. This is custody and guardianship. That is visitation.
All right.
Even though they tried to attach a custody claim to the third-party visitation case, they ultimately withdrew that because they don't have standing to do it.
All right.
So let me just see where I was at. So the use of this is cloak and dagger secrecy type stuff in probate court. The use of the motion 52196, a special motion to dismiss, it's anti-SLAPP. It's a misuse of process. Ultimately, the probate court matter was abandoned by Lori Hepburn and Tom Esposito, and they started a new case elsewhere. And just so you know, 5280 and 46B7 says they can't leave the scene of the court while an evaluation is pending, and they can't withdraw in the face of an adverse ruling. And Palumbo v. Barbados, which is a 2016 Connecticut appeal case, says you can't do it either. The case was already won by the time Tom Esposito showed up. Well, I guess we'll deal with Tom in a little bit.
Yeah, yeah. This one is particular to the claim because they are separate claims against Ms. Hepburn.
Yeah. So Ms. Hepburn filed for custody and guardianship. She filed for immediate custody, temporary custody, removal of guardian, and appointment of herself as guardian in probate court. And immediate custody was denied, temporary custody was withdrawn, removal of guardianship was withdrawn, and appointment of a guardian was withdrawn.
That's bold. For the child to have lost their mother Their mother passed away. And the aunt steps in and says, I'm taking custody over the father. Father doesn't apparently get a say, according to the aunt. That is wild.
During that time frame, they did grant her visitation. They granted her video visitation, and then they assigned a supervised visitor, a visitation supervisor. And after the GAL weighed in, after DCFS weighed in, they issued a no contact order against Lori Hepburn. And that has never been adjudicated, or the Supreme Court didn't know about this, and the Superior Court doesn't know about that either. And Tom Esposito is trying to make it go away, but it's still there.
All right. Okay.
Separate matters, though: visitation, custody, and guardianship.
All right. Okay. So thank you. I think the oral argument is very, very helpful to the court. I've obviously read everything very carefully. So I will take the information that you've provided certainly in consideration when I issue the decision.
May I have the chances to reply briefly, Your Honor?
Yes.
I just want to say that Mr. Brill is essentially arguing the facts in the underlying cases. That's not why we're here. We're here to determine whether or not Ms. Hepburn had probable cause. And I mentioned it in my brief. On the remand, Judge Nieves, in that underlying decision, made a finding that she had a colorable claim in the probate matter, ergo she had probable cause. I also wanted to bring to the court's attention, I didn't mention this in my argument, that and the court may ignore this or choose to not make a big deal about it, but Mr. Brill did not file his objection within the 30 days of Practice Book Section 10-31A. It should have been filed, I believe, on the Friday. He didn't file to the Monday, which was the last day that we're supposed to argue this. So that's something that the court can consider as well.
Yes. Okay. All right.
Honor,
So yes, go ahead.
There's been a number of issues with filing with 30 days, and that was cut off on my part. So I would like some leniency there. I would appreciate leniency anyway, if you'd be so kind. And I'd like to, if you could do a little investigation as to why things were filed as motion for orders as opposed to motions to dismiss, and why papers were taken, take papers, marked take papers as opposed to marked oral arguments. There's just been some weird stuff going on here. I don't quite, doesn't make sense to me.
All right. So I'll absolutely look at the docket entries.
Just final argument. Lori Hepburn never even had standing to sue for custody or guardianship. And if you look at Fish v. Fish, it explains it. Third parties don't have standing to sue for custody or guardianship. Maybe they have a right to file for visitation, but they don't have standing to sue for custody or guardianship. That's all.
All right. Thank you. All right. So next, and we'll just repeat this for our court monitors. So next, we're going to move on to Brill versus Esposito and Garnett, DVD-CV 255-022-340. Again, a special motion to dismiss at docket entry 103 and a memorandum of law at 104. Again, we hear from the movant first.
Yes, if Your Honor, please, Attorney Ray Pluff on behalf of Thomas Esposito and Clifford Garnett. I am going to start initially with following up on Attorney Leventhal's most recent point about the untimely and late filings submitted by Mr. Brill. Practice Book 1031A provides that objections to a motion to dismiss have to be filed within 30 days of the filing, or they can't be considered. And Mr. Brill knew that his filings had to be made by November 10th 2025, because Your Honor issued your order at docket entry number 103.01 requiring that. That's docket number 103.01. Mr. Brill's, if you look at the docket filings, are all beyond that date, and they are late and they are untimely. And I, on behalf of my clients, and Mr. Attorney Leventhal, on behalf of Ms. Hepburn, has objected. I'm objecting to your consideration of any of those. And in connection with that, Your Honor, we actually had filings submitted today, November 18th, by Mr. Brill. And I filed a formal objection to those about 15 minutes before the hearing because I just saw them. So there is a formal objection on the record to those. There are verbal objections at this hearing, and the court should not consider any of that. Furthermore, on a special motion to dismiss or any motion to dismiss or a summary judgment, only evidence that is admissible in court can be considered. The arguments of Mr. Brill and the arguments of counsel are not evidence. So I would ask Your Honor, and I know you understand that, to only consider evidence in this proceeding. Furthermore, Judge, and again, because of the late filings and Mr. Brill's attempts to try to shift things back to the probate court, the court should take and could take judicial notice of Mr. Brill's appearance in the case, or not appearance, the return of service as to when the action was returned in my case. And that return of service, I believe, it's docket entry 100.30 was August 26th, 2025.
So what standing does this party have for the child? I mean, I can kind of get where the aunt is like, hey, I'm family, I'm the mom's sister, I've got a right to, raise the child in my sister's wishes or something along those lines. But what does Mr. Esposito have for a relation?
A reading of Mr. Brill's complaint deals with a number of things in both matters, but his allegations regarding the probate court all relate to hearings in June of 2022, July of 2022, an allegation that even though a motion was withdrawn by my clients on July 19th in court, there was a formal withdrawal on August 15th, 2022. And along with that, I'd ask the court to take judicial notice of Connecticut General Statutes 52-577. That is the statute of limitations that applies to vexatious litigation actions. It is a 3-year statute of repose. Anything that occurred prior to August 26, 2022 is time barred. An action in Connecticut is not commenced until the time of service. It is not commenced on the date of the complaint. Its date commenced on service. So all of these allegations about the probate court, I submit, are time barred. And the reason this is relevant is Mr. Brill's burden is to show that he has probable cause. He's going to win this vex action in light of all available defenses. That defense became known to me essentially. When I started reading his memorandum he filed today, and he's starting to try to shift things to the probate court, there it is. I mean, it's there. I think you can consider that and take judicial notice of that. Moving on to what I would consider the main argument, if Your Honor please, is that the petition for visitation by a third party is brought pursuant to Connecticut General Statute Section 46B-59, which is the procedure the legislature has adopted and made law for petitioning for the right of visitation with a minor child. That is not an abusive process. That is use of a process for the specific purpose for which it was designed. The legislature has provided that the petition is to be addressed by the Superior Court, not a probate court. That is, and if I may, Your Honor, I'll quote from the statute at section 46B-59, parentheses, small b. Any person may submit a verified petition to the Superior Court for the right of visitation with any minor child. The Superior Court is the court to which this is to be addressed by statute. This is not an abusive process. The subject petition, as brought out by Attorney Leventhal, has, and the affidavit, the verified petition and the verified original petition for guardianship, they've both been reviewed. And the Supreme Court found that there was ample evidence to warrant that this petition should be determined on the merits. And they remanded that, and the matter is scheduled for trial now, I believe, in March of 2026. A finding by the Supreme Court that there was probable cause to proceed on the merits, the finding by the Superior Court also finding that Miss Hepburn was credible and that her matter sufficiently stated a basis to proceed even with termination of parental rights. Those are prior determinations by court that there was probable cause to not only commence, but to maintain the action through a trial on the merits. And importantly, Your Honor, probable cause does not dissipate. It does not vitiate along the way if there's an adverse ruling. I think Mr. Brill is confused on the law in that regard. The law is actually, you can lose pretty much every motion along the way, and you can even lose the final hearing on the merits, and that doesn't mean there wasn't probable cause. Probable cause is, if I paraphrase, there's sufficient information that would lead an ordinary person to believe there's enough there to proceed with the claim. Well, I submit our Supreme Court, and I submit that the Superior Court judge looking at this are all reasonable people who found that there was certainly enough to proceed with this claim on the merits, and it is scheduled to proceed on the merits. That is a finding of probable cause. Probable cause is a complete defense to Mr. Brill's cause of action. The statute of limitations is a defense to Mr. Brill's cause of action. These matters unquestionably involve matters of public importance. We've briefed the issue to the court that use of the courts, petitioning to the courts is appropriate use of free speech. And along those lines, Your Honor, Connecticut General Statutes 52-196 small a, subparagraph small a, subparagraph 3 actually indicates that petitioning the government is defined as communications regarding issues of public importance that may be considered or reviewed by the legislature, executive, administrative, judicial, or other government body. Following up on that, Your Honor, the United States Supreme Court case, if I just have a moment, Your Honor, of California Transport versus Trucking Unlimited, 404 U.S. 508, 1972, in a different context. I think it was a Norr Pennington type context, but what it stated in that case is directly applicable to this case. And the Supreme Court said, certainly the right to petition extends to all departments of the government. The right of access to the courts is indeed but one aspect of the right of petition. And our statute says that, the Supreme Court of the United States says that. This is the underlying actions are petitions to the court to exercise rights provided by statute. Now, under the special motion to dismiss standard, the burden shifts to Mr. Brill that he can establish by probable cause that he's going to win his VEX action. And we know the underlying, the VEX action has never been determined. The underlying action in the Superior Court has never been determined in Mr. Brill's favor. In fact, we have findings by the court that there's probable cause to proceed to a hearing on the merit. That is the death knell to a claim that the Superior Court action is vexatious, essentially as a matter of law. And I think, again, if Mr. Brill wants to focus on what happened in the probate court, anything that happened there is time barred. He doesn't have probable cause he's going to prevail there.
When he says time barred, and I know he's referring to the statute of limitations, but is it something similar to how it works in other statute of limitations where it's not based on the initial filing, but on the last action? So, maybe that's what he's going on as far as it not being outside of the statute of limitations was, maybe the last action was a year ago or, something like that. I'm not sure. This is why I'm not a lawyer, but that's just my speculation, is if he could get past the statute of limitations with that logic.
In this action. And I think as far as my clients, attorneys Esposito and Garnett, they have the right, and we've cited the court to case law, they have the absolute right to rely on a verified petition filed by their client as a basis for probable cause. They have a right to rely on the Supreme Court's finding of a prima facie probable cause situation and the right of the trial court finding the same thing. And even if along the way motions might be determined against Ms. Hepburn, it doesn't destroy probable cause. They're two totally different issues, and we've briefed those issues to the court. And I think if Your Honor, please, we have submitted with our special motion to dismiss the verified petitions. Those are matters that have been verified under oath. We've submitted an affidavit on behalf of attorneys Esposito and attorney Garnett. And I would submit that the plaintiff's submissions, while the court can, I guess, look at rulings in the probate court and in other items, I'm not so sure the DCF reports or any of that is admissible evidence in the form it is in. I don't think it is. I don't think the court has to consider it or should consider it in this proceeding. But if the court were looking at it as Attorney Leventhal pointed out, there are findings in those submissions by Mr. Brill that actually prove probable cause. Many of them relate to continued access with the aunt, replete, different visits, supervised visitation, communications, and things of that nature. There were continuations of Zoom matters. And if I might, I think it was Mr. Brill's untimely November 11th objection, Exhibit C, was a probate court study. And if you look at that, Mr. Brill admits he met Halle Berry in 2009. They were in a relationship for 2 years after the child was born. The relationship ended. I asked the court to take particular notice of Mr. Brill's contract with Halle Hepburn. It was for, an adult relationship without any responsibility for any children that may be spawned from that apparently unprotected relationship that they agreed to. Mr. Brill didn't want any involvement with his spawn from the get-go. When the child was born, the relationship with...
I think Attorney Clough is wrapping up. I will hear from you, Mr. Brill.
Okay, I'm not done yet with my argument, Your Honor.
No,
But
he had stated something, so I'm just letting him know he will
not a
have his
valid
turn.
contract.
Okay, and then if Your Honor...
Yeah, he stated objection. Unfortunately, his mic doesn't kick in right away, and it takes a minute for his mic to get up to a sufficient volume to hear him. But he said objection. That should right there make everybody stop talking until the judge rules on whether it's a valid objection or not. And that's not happening. That makes me mad.
Please, that same document relied on the plaintiff indicates that Mr. Brill was residing in Massachusetts with his girlfriend, Jennifer Underwood, at the time of Miss Hepburn's passing. That finding also indicates, this is a quote from that finding about Mr. Brill, he is keenly aware that his daughter's choice is to remain residing with her aunt. This has created significant conflict between he and Lori Hepburn. It also says there, Mr. Brill has the child engaged in mental health treatment and recognizes that, and he says in here, he is disappointed to be battling Lori Hepburn over his child care. He notes there has been resistance from her in many areas and recognizes that she has been a regular caregiver for the child for many years. These all go to probable cause. It's a finding is there. All these factors are specified in 46B59 to be considered amongst others. It's there in Mr. Brill's own submission. There's another finding in that report that the minor child is a special education student. The minor child was very open and assertive, expressing her wish to reside full-time with her maternal aunt, Lori Hepburn. The minor child felt that Mr. Brill doesn't listen to her at times and use words and phrases such as feeling unsafe, quote, unquote. It was apparent that the minor child has anxiety over the uncertainty of what is occurring. When asked why she could not be happy with her father, she indicated that living with her father was not her quote unquote home, and she wished to reside with her aunt. I mean, I can go through these documents that Mr. Brill attaches,
Your Honor,
but they establish, if Your Honor, please, probable cause.
Wait, hold on.
Everything else.
Hold on. Maybe people can't hear me, but we're speaking one at a time. So, Mr. Brill, you will have an opportunity in a moment.
So if we look at the whole panoply, if Your Honor, please, of probable cause, from the get-go, and now a finding that these issues, the visitation and again, the verified allegations that the Supreme Court was looking at were exactly the same as those that the Superior Court looked at on the guardianship matter, and the Superior Court in that matter issued the facts assessed by the court upon appeal. This is a quote, are the same facts that existed at the time of the filing of this present petition, that's the petition for guardianship, and as credibly testified to by Ms. Hepburn in this court. In sum, plaintiff had at the time of filing this present action a colorable claim to guardianship. So as far as a colorable claim to guardianship, a colorable claim to visitation under the statute, these determinations have been made. There was probable cause to proceed. There still is probable cause to proceed. And I think based upon the framework of a special motion to dismiss, the motion to dismiss should be granted, Your Honor. Thank you.
All right. I'll hear from Mr. Brill now.
So, Mr. Plouffe, excuse me on the pronunciation. What is it?
It's Pluff, but that's okay, Mr. Brill.
Mr.
I have a
Plouffe,
hard time hearing you, Mr. Brill. If you could turn up your mic, I don't know if I'm the only one, but I'm having a hard time hearing you. But go
speak
ahead.
loud. The motion 103 was for order. It wasn't labeled a motion to dismiss or a motion for a special dismissal. It was marked take papers. He shouldn't even be allowed to argue this. It was deceptive what he did, and I'm pretty disappointed. Okay, let's start with that. The return of service. I filed this case on August 5th, knowing that I was attempting to comply with the statute of limitations. I was at Danbury Courthouse on August 5th. In fact, Judge Medina walked down, and I think he had a conversation with the clerk that day to wonder why this is an additional filing to the Jill O'Connor case. Just so you know, Jill O'Connor was the original attorney, and that case is going to a jury on December 16th. Jury selection is December 16th. So the Honorable Medina found that I had probable cause to file the matter, and I would think that you might find the same thing as well, Your Honor. I think it because it's not like somebody was shot with a bullet. It was coercion and mental illness in the home, and there was brainwashing. In 5th grade, my daughter was labeled low IQ and special needs, and today she's an honor roll student and in accelerated classes. So there were significant problems in the home, and if you notice in the GAL report, the school psychologist indicated that after spending 1 month with me, the child's outbursts and anxiety had come to a halt, and she was appearing like a normal child. So definite improvements. Kay Campbell was a real benefit to my daughter, and I made a move to Weston, Connecticut for the sole best interest of my daughter, so that she could complete 5th grade, and then we moved back to Massachusetts according to plan, and that's all been adjudicated. And the one thing that the Honorable Nieves did, I don't see how she came up with that conclusion that she had a colorable claim to guardianship. There was a no contact order. She lost on immediate custody. She lost on she was withdrew on temporary custody. There's a no contact order and a psych eval. It's not possible for her to obtain guardianship on July 18th. And I think that was a colossal plain error. And I think that the state of Connecticut just wanted jurisdiction. And the orders from the Supreme Court are pretty clear that and maybe there's a few exceptions, but once the Supreme Court has ruled that it goes to a evidentiary hearing, it goes to an evidentiary hearing. Now, it took over a year to figure out UCCJEA jurisdiction, and it still, in my opinion, hasn't been figured out correctly. So with that said, there's a few other items I'd like to, let's just see, I had a few other notes here. Contact order was omitted. Yeah, so you go to the Supreme Court and you omit the fact that there's a no contact order. It's called omission fraud. It's very, very disappointing to me, Your Honor. I can't believe this kind of thing goes on in the courthouse. And as far as probable cause goes, it's really wanted probable cause. I've listed a number of ulterior motives. She wanted the child. She wanted me out of the picture. She wanted control of the family finances. And in fact, let me just go to that right now.
So there was money in the estate that she wanted control of. Yeah, that's gross.
Just remember, for this type of motion to dismiss, you really need to focus on the statute. There's a controlling statute. That's the legislature. The court does not have the ability to substitute itself for the legislature. The court has to follow the statute. So I'm not cutting you off, but I I want to make sure that you understand that it would be most helpful to the court if your focus were on the statute.
So the statutes that apply
Excuse
in
me.
probate court range from 45A 606 to 45A 616. And it has to do with custody and guardianship, and it's governed by Fish v. Fish, which is a 2008 case, which says third parties do not have standing to sue for custody or guardianship. And that was the filing in probate court. The fact that the probate judge granted visitation and then pulled it or revoked it later on is it's now part of the record, but that part of the record was left off when they went to the Supreme Court. So the probate case was essentially finished or abandoned on July 19th or withdrawn by Tom Esposito orally, and then withdrawn on August 5th in writing by Tom Esposito. Okay, but that's a custody and guardianship case in probate court. On July 18th is when they filed for third-party visitation. So understand that, you know, the vexation, I won on all counts on custody and guardianship and on visitation in probate court. The merits of visitation haven't gone to an evidentiary hearing yet in Superior Court. Okay, but that's
a factor this court has to consider.
Okay, so 46
That is not a completed matter.
So, but the probate court matter is completed.
But not the Superior Court.
Okay, so I'm not suing for what's happened in the Superior Court. I'm only suing for the vexatious and malicious conduct that occurred on June 9th by Tom Esposito, when he said I should be held in contempt for my actions. And then he threatened to threaten my guardianship rights on July 19th. So I'm pretty upset with Tom. He knows that. And I'm very upset with Lori Hepburn, who filed for ex parte. I didn't even have a right to be present. I didn't have a right to an attorney on November 17th, 2021, and I won. Judge Maxim denied immediate custody. And then on April 4th, temporary custody was withdrawn by Lori Hepburn and her attorney, Jill O'Connor.
And
Okay.
I am very familiar with, I've spent a great deal of time on this. Very familiar with what occurred in the probate court.
Okay, so this is about the probate court in 210700, not about I can't say the CUSIP number offhand, but the Bridgeport Superior third party visitation case. The two separate cases. The custody and guardianship filed in probate court is a different matter than the third party visitation case that was filed by Tom Esposito and Lori Hepburn on July 18th. And what's so disappointing too is they were parallel jurisdictions, and the UCCJEA says you can't do that, but in Connecticut you can do it anyway, according to Tom and Lori.
Okay.
For being pro se, he is darn good.
Was there anything else?
I think that the rest you'll find in the papers, Your Honor.
I think so. All right. So I want to thank everyone for the presentations today. It's very helpful to the court. I know it's very important for the parties that I rule just as quickly as I can. So I'm going to consider the briefing again. I'm going to consider the oral argument today. I have the ability to re-listen to parts of it if my notes are fail me. I don't think they will. I've been taking, you can't see, but I've been taking copious notes throughout the hearing. And so I want the parties to know that I understand just how important this is to everyone. I will do my very best to issue a decision just as quickly as I can. And I want to wish everyone well. So our hearing on this matter is adjourned. And thank you to the clerk and to our monitor.
Thank you, Your Honor.
Thank you, Your
Thank
Honor.
you, Your Honor.
Thank you. All right. We're in recess, everyone.
So we don't get to know the judgment, which is disappointing. I hate that part. But we get to speculate and come up with our own happy endings for it. So what I want you guys to do is in the comment section, let's all say what we think the judge ruled, or how we think the judge ruled, or how we think the judge should have ruled. Comment section. Remember that.
All right, next case, calling cause number 25-01-0065-CBA, U.S. Bank National Associate versus Huth and the unknown heirs of Huth.
Good morning, Your Honor. Robert Valdespino for the plaintiff.
Okay.
Hi, Judge. Morteza Karimi on the ad litem.
All right, and Mr. Valdespino, what do you think we're doing today?
Your Honor, this is a petition to foreclose on a home equity mortgage loan. Both of the borrowers passed away. We hired a private investigator who found that there are two children of the decedents. One named Ellen Hirth and Walter Hirth. I'm sorry.
I think Walter.
The children are Russell and Teresa. And one was served personally, and the other was served by alternate service.
Right. So at this time, I'm taking judicial notice of the entire court's file. I find that Teresa Huth was served on May the 6th of 2025, and Russell Huth was served on March the 6th of 2025. Neither has filed a responsive pleading, nor have they otherwise made a general appearance in this case, and I find they are in default.
Okay. And then the unknown heirs, we recently filed a motion for partial non-suit to non-suit the unknown heirs.
I do have,
to sort of clear the path.
I'm sorry, say again.
I said to sort of clear the path for a default judgment.
Okay, so I do find in my e-file that I do have a motion for partial non-suit. There's a blank in there for the sum of attorney's fees to be paid to the ad litem. So, Mr. Karimi, what are you charging for your services?
I asked for 5,000, and I've talked about it, and I believe they were okay with it as long as you approved it. So if Mr. Valdespino doesn't have an objection, but that's what I'm asked about.
Mr. Valdespino,
Your Honor, I'm kind of caught here in between a rock and a hard place, because when the fees appear to be reasonable, we usually just agree to them and we put it into the order. $5,000 seems extreme, since it was just a 2-page ad litem report, and most of the information is what we provided to the ad litem through our private investigator's investigation. And our private investigator had a 2-page report. So we just want the court to decide how much of the ad litem fees were actually earned. And normally we see a ad litem report requesting attorney's fees with detailed amounts and time. And there's
Mr. Valdespino, let me ask you, what is your proposal for the amount of the attorney's fees that you think would be reasonable, and see if Mr. Karimi will agree to those?
Well, generally we see these between $1,200 and $1,500 for the amount of work that an ad litem would need to do, given that they start off with a lot of information that we provide.
All right, Mr. Karimi, they're saying that they'll pay you $1,500. Do you agree or disagree?
I mean, if I can just say something first. I've been trying to work this out with them. I asked them, like I said before, I have the email where I asked for 5,000, and the attorney for them said they will pay it as long as you approve it. That's what they said. And then I tried, then they asked for a fee report. I'm like, well, if you agree, you can put it in the judgment. If you have an objection, if you don't agree, you tell me, and we can work something out. That's not a problem. They never, I mean, it was just, I was trying, it was like pulling teeth. I said, okay, if you don't agree to it, tell me a price. If they would have told me this before, I would agree to it. Maybe I wouldn't even have to have been here today. I mean, I understand where Mr. Valdespino is coming from, but like I tried to work this out a long time ago. So how, if I can ask Mr. Valdespino, how about 2,000? Would that be acceptable?
Your Honor, if I may address that, the reason that we didn't just outright, or rather, the reason we didn't negotiate with the ad litem as to the 5,000 fees is because he represented to us that this is a flat fee that he normally charges in this county, and that the court always approves them. And we said, well, then we'll let the court decide what your fees should be. If the court approves it, then the court approves it, but we just couldn't agree to 5,000.
All right, now Mr. Valdespino, Mr. Karimi has made a counteroffer of 2,000. Do you agree to 2,000?
I think that's simple.
I'm sorry, I didn't hear what he said.
Well, I'm just listen to what I had to say. Mr. Valdespino, Mr. Karimi has now made a counteroffer of $2,000. Do you accept $2,000 as reasonable attorney's fees?
Yes, Your Honor, we can go with that.
All right, so
more
I'm
than we
putting,
normally agree to, but okay.
It sounds like Mr. Karimi is taking advantage of the fact that there is an estate involved, and because $5,000 for a guardian ad litem, that is exorbitant. That is absolutely outrageous. I have never heard a guardian ad litem charge that, especially not in something that they wrote a 2-page report and all of the information was given to them. That is a wild amount. And you know that he knows he's taking advantage of the estate, because it went from 5,000 to 2,000 instantly. That is the biggest attorney discount I have ever seen. It was like manufacturer's coupon special, That's crazy. Look at that face. Oh man, that face. He looks like a scammer.
so I'm putting $2,000 in that order, and I'm signing the partial non-suit and forwarding that to the clerk for filing. And did you want to proceed with your default judgment today, Mr. Valdespino?
It was my understanding that the court would require us to have a separate setting on that, but I think I can go forward with it. I didn't prepare for that, but the court has.
Well, you let me know. If you're not prepared
Yeah.
for it, then I can set it for another day. If you are prepared for it, I think you have what you need attached to your
Yes, Your Honor.
petition.
I think we have everything we need. I just don't have all the dates when the defendants were served, and given that the unknown heirs have been dismissed, if you've already signed the order, then I think the default is appropriate. And keep in mind, Your Honor, this is in rem relief because it is a home equity, and all we're seeking is to foreclose on the property. We're not seeking any monetary relief. We're not allowed to.
Right. So I tell you what, how about you just kind of, I got like a couple other cases. I'm going to call those, and then I'll come back to yours to give you just a few seconds to collect your thoughts. If you want to do this default judgment, I'll come back to you after I get finished with these other couple of cases. How is that?
Okay. Well, why don't we just set a default motion for default hearing? Because I'm the local counsel. I haven't, they just sent me the file recently, but maybe it would be better if someone from the firm that is the attorney of record handled the default.
If I reset it for December the 17th, is that enough time?
Yes, sir.
I'm going to reset it for December the 17th. I got to look and see when a good time might be. It's probably December the 17th at 3:30.
Okay. I have made note of that, Your Honor.
Set it for a default hearing on that day. All right, Mr. Valdespino and Mr. Karimi, you are excused.
Thank you, Your Honor.
Thank you, sir.
In the matter of People versus Vasquez, 254210, appearances for the record.
Morning, Your Honor. Zachary Answer on behalf of Ryan Vasquez. At this time, Judge, we would waive the reading under plea of not guilty. Request referral to the Office of Assigned Counsel.
Under plea of not guilty, Office of Assigned Counsel. Probable cause conference, 11/26 at 1:30, preliminary exam 12/5 at 8:30. That's in front of Judge Clark. As to bond for Ms. Vasquez.
Judge, as the bond, I would just note she lives at Crest Lane Drive, Saginaw, 48601, lifelong resident of the community. She is I'm sorry?
I have her address already. Please don't say it. No need to. Please go ahead.
Thank you, Judge. I would just ask for a reasonable bond in this matter, Your Honor.
She's on parole, is she?
Probation, I believe.
Probation, circuit court. Yes. Miss Vasquez, what's your agent gonna do with you?
I don't know yet.
She hasn't seen her agent yet, Judge.
All right. Well, looking at your history, you going through a store is like Dr. Magneto going through Clingston's. 5,000 grams is cash surety at this time. When your agent figures out what he or she's going to do with you, then the courts can too. All right, that's the day. In the matter of People versus Rogan on 2466663 715 857 A 4465606B. Appearances for the record.
Good morning, Your Honor. Zachary Answer on behalf of Ms. Rogan. Judge, on file 663, at this time, we would waive the reading under plea of not guilty. Request referral to the Office of Assigned Counsel.
She failed to appear for, it looks like she's just failed to appear for court dates. With regard
Okay,
to this, though,
I have
the civil infraction on a registration plate. I will recall the warrant and then just suspend. So that takes one down. With regard to the other matter, failed to appear as well for a pretrial. Is there a reason she didn't want to come back to court in April?
Judge, she didn't recall knowing she was supposed to be in court at that time. I would just note that the address the court has is the same address that we'd use right now.
Okay. I think she may have warrants out of Bay City as well.
Yeah, Judge.
Warrant, it just makes it so much easier. And all you have is traffic matters. And we want to do everything we can to get you a license or get you on the path to get the license. But you're not helping that at all by not showing up to court. Are you working?
Yes, Judge. She is employed as a SENA at Stratford Pines.
Yeah, her warrants are out of Carroll, not Bay City. Well, I take that back. It's also out of Bay City. Bay City has a 100-mile pickup, and looks like Tuscola County has a 100-mile pickup. There we go. All right, well, let's do this. I'll take under advisement, see what the other counties are gonna do. At least there's gonna be at least a reporting. Please come to court. We'll take care of these and try and get you on a path for your license. But you gotta meet us at some point. So, all right, you're all set.
Thank you, Judge.
Thank you. In regards to People versus Coleman, 223376 and 252922. Let's start with the misdemeanor file on why he failed to appear for a probation violation of Raymond on October 27th before Judge Clark.
Well, good morning, Your Honor. David Roby on behalf of Mr. Coleman. I'm not sure if you understood that that's a direct question to him.
Yeah. Is there a reason why I didn't show up? Here. Let's just do this.
Okay.
This was felony file. On 252922, waive the reading.
Yes, we waive the reading. Stand mute. Ask for a referral to OAC.
OAC, court winner plea of not guilty. Probable cause conference. 11/26 at 1:30. Preliminary exam is 12/5 at 11. That's in front of Judge Clark. And then as to bond on the new file, please.
Excuse me. As to bond, Your Honor, Mr. Coleman does have, although he's a nearly lifelong resident of the county, he's got a job pending. He's in the process with GM. He's not been officially employed. but he's feeling pretty good about it. He has no, he's not presently on probation nor parole. So I'd ask the court to consider a PR bond for both matters.
Given that he has demonstrated a failure to appear, there's Judge Clark also, this is a third violation with regard to the domestic violence case. Given the history of intimate partner abuse, also given the assaultive history, bond would be set at 5,000 cash surety, 10% in accordance with Judge Clark's bond, and then 2,000 cash surety, 10%, no contact with the victims, no firearms, no illegal controlled substances, no alcohol, in accordance with the bond guide.
Thank you.
People versus Collins on 254191 and 892-9717 A, B, C, 2621304 A, B, 892-8865 A, 892-8757 A. All right. Full load of tickets. What are we gonna do?
Thank you, Judge. Zachary answer on behalf of Mr. Collins. Judge, this time we would waive the reading under pleas of not guilty, not responsible as applicable. Request an informal hearing as well as referral the office of assigned counsel.
Set for a formal hearing, given that he has, well, plead not responsible, set for formal hearing. Court want to plead not guilty. Is there a reason why he's not taking care of his tickets or coming to court on them, or?
Oh, there shouldn't be. His shirt says he's wealthy. He shouldn't even need the office of assigned counsel. Clearly, he announces it proudly. He's wealthy.
Why did he not come for arraignment? I recall the warrant on the one.
Yeah, Judge, I don't really have a good excuse or answer. I would just note that Mr. Collins is currently employed at Mid-Michigan Trust. Talk to him about the need to get his driver's license situation handled. And, you know, now that all these matters are before the court, he can come back with an attorney and get them taken care of.
Given on 892-9717, well, the people haven't really indicated why a bond other than PR bond should be put in place. It's fair to appear on the prior tickets. Of course, it's going to put a $500 cash surety, 10% bond on that to ensure things. All right. In the matter of People versus Wadley on 235081, 235082, these are income tax cases. Really?
Yes, good morning, Your Honor. David Roby on behalf of Mr. Wadley. And that's right. Who stands mute? We waive the reading. We ask it.
Well, they're already under a plea of not guilty. He's failed to appear. On file number, Mr. Wadley, on file number 235081, this is your fifth failure to appear on an income tax matter. I'm sure we have said this on at least 5 prior occasions, that all you had to do was go to City of Saginaw to meet with them to put up a payment plan or to resolve if you do owe it. I cannot any longer do a PR bond. This is now the 5th one with about $20 per failure to appear. You've now cost the taxpayers over $100 in administrative fees of just getting these files set, let alone all you got to do is drive around the city of Saginaw to see their condition and why they need their tax dollars. So I'm going to put a $145 cash only bond on 235081. That is the amount that's alleged to have been owed in the warrant year. And then with regard to 235082, the amount is $487. So do a $500 cash only bond on there. I'll refer these back to Judge Clark and then let him to decide what to do with the files. You're all set.
Very well.
Ooh, the judge got clever with that bond. Yeah, he's only getting out if he pays his income taxes.
With regard to the last one, People versus Angela Lasecki on 252250. Appearances for the record.
Morning, Your Honor. Zachary Answer on behalf of Ms. Kaseki. Judge, we would waive the reading under plea of not guilty. Request referral to the office assigned counsel.
Court will enter plea of not guilty, office of assigned counsel as to bond, please.
Judge, as to bond, I would just note this, in this felony warrant, Ms. Kaseki is only charged with retail fraud in the second degree, count 3, conspiracy to commit. She's a lifelong resident of Bay County, Judge. No pending criminal matters. She's not on probation or parole. Her criminal history is old, Your Honor. We're going back 20 years to her last conviction. I would ask that she be released on her own recognizance, with a trespass to minor.
And if she were drug tested, how would she test?
Judge, we had no indication of any drugs at the time, so I did not ask her. Ms. Kaseki, what would you test positive, if anything?
Yeah, no, she has a bench warrant out of Bay City. In addition, this court would have concern with your bond will be set at 4,000 cash surety, 10% bond. All right. Thank you, jail. Thank you, Mr. Yancey. Thank you, Mr. Luddy.
Thank you, Your Honor.
Thank you, Your Honor. And thank you guys. Oh, I'm so happy that that you guys came out and hung out with me tonight. I definitely missed you. I right now I'm missing my bed though. If you can't tell, I'm still not feeling 100%. I don't know if I'm coming back on tonight or not. Hi, Billy. I'm not sure yet. If I do, it's just gonna be body cams, because that's all the court stuff that I had ready, and it took me a couple of days to put that together, just because I'm just so out of it. So I'm sure trying. Thank you. I love you guys. I know, so do I. So do I, but I've not been well for a few days. If my face is any indication of me not feeling well. Yeah, this fabulousness. When I get sick, my face breaks out, and it doesn't. You would think, you get sick, your face breaks out, you get better, your face gets better. No, that's not how mine works. Hello, Mark Addy. I know, I watched it, and it would be one that I run, so don't say anything about it. If I come back tonight, you guys, I'm gonna go and try to take a nap. And now that you all are forewarned that it would just be body cams, I'm gonna try to take a nap. And then maybe I can stay up. We'll see. I would have to first wake up. So. Oh, Jerry, you're so sweet. Thank you. Ava's gonna be absolutely stoked. Thank you. I'm sure trying. The PAWFURM is definitely trying to help me feel better. Hold on, because not everybody has Discord. Hold on. Billy, hey, okay, fine. This is it. last of them. You're not getting more after this. I will put them in the safe if I have to. Hold on one second. Okay. So this is my face with Billy right up cuddling on me. And then this was, you can see my rear end. This was behind me. I had Ava at the top of my head and then Earl at my back. Yeah, they were trying to make me feel better. And then tonight, so this is what I did tonight. I took an old cooler that had a broken spigot and I cut a hole, and then I used duct tape to seal around it to make it so that it wasn't no sharp edges or anything like that. Excuse me. And then I put a little bathroom rug in it and a cloth mat pad thing. I'm gonna make a hood to go over the hole to protect it from rain. Billy went right into it. My baby. And then he didn't want to come out of it. He liked it in there. But yeah, so I made that. Now I don't have to worry when it's winter time and Tiny Kitten and Billy want to go outside. So no more treats. No more. You've had plenty. You have had enough. No. You've had too many, to be honest. You're getting chunky. Yeah. You're a big boy. All right, guys. Billy, you're hitting things with your tail. Thank you guys for coming out tonight. I love you all. Be safe, be well, sleep sweet, and much love.